5 seconds to go. Start. Any interpretation or formulation of the law must duly take into account valid concerns of road safety bearing on the safety of users of public transport facilities. Any change in the position of law as expressed in Mukund Devgan Supra would undoubtedly have an impact on persons who have obtained insurance relying on the law declared by this court and who may be driving commercial vehicles with LMV licenses. A large number of persons would be dependent on the sector for earning their livelihood, and the decision in Mukund Devgan Supra has held the field for nearly 6 years, and the impact of the reversal of the decision at this stage, particularly on the social sector, is a facet which would have to be placed in balance by the policy arm of the government. The considerations which have been flagged above do not necessarily weigh in the same direction. However, all of them do raise important issues of policy which must be assessed and evaluated by the Union government. Whether a change in the law is warranted is a matter which has to be determined by the Union government after taking a considered decision bearing in mind the diverse considerations which fall within its remit in making policy choices and decisions. Having regard to these features, we are of the view that the issue of interpretation, which has been referred to the Constitution Bench by the referral order dated 8th March 2022, should await a careful evaluation of the policy considerations which may weigh with the government in deciding as to whether the reversal of the decision as it obtains in Mukund Devgan Supra is warranted, and if so, the way forward that must be adopted, bearing in mind the diverging interests, some of which have been noted in the earlier part of the order. Hence, in view of the consequences which may arise by the reversal of the judgment in Mukund Devgan Supra, it would be appropriate if the entire matter is evaluated by the government before this court embarks upon the interpretative exercise. Once the court is apprised of the considered view of the Union government, the proceedings before the Constitution Bench can be taken up. We request the Union government to carry out this exercise within a period of 2 months. We clarify that we have not expressed any opinion on the merits of the referral order dated 8th March 2022 or on the correctness of the decision in Mukund Devgan Supra, which would await further arguments once the considered view of the Union government is placed before this court. In view of the consultative exercise being carried out by the government, the matter was deferred multiple times. On 16th April 2024, a note on the proposed set of amendments to the MV Act was submitted before this court. On 21st August 2024, the learned Attorney General R. Venkataramani had suggested that the matter be either deferred till the amendments are tabled before Parliament or the court may conclude the pending hearing. We then proceeded to hear the part heard matter on 21st August 2024. We have heard Mr. Tushar Mehta, Learned Solicitor General, Learned Senior Counsel Mr. Siddhartha Dave, Mr. Jayant Bhushan, Ms. Archana Pathak Dave, Mr. Neeraj Kishan Kohl, Learned Senior Counsel Mr. Amit Kumar Singh, and Mr. Shivam Singh, Learned Counsel on behalf of the insurance companies. Mr. P.B. Suresh appeared as a sporting intervener for the Society Against Drunk Driving. Mr. Siddhartha Dave, learned senior counsel, took us through those provisions of the MV Act and MV rules that create a distinction between light motor vehicles and transport vehicles. The Council drew the Court's attention to Section 3 of the MV Act, which stipulates the necessity for a driving license to drive a motor vehicle. He referred to the second part of the provision, which states that no person shall so drive a transport vehicle unless his driving license specifically entitles him so to do. It was contended that Mukund Devgan 2017 overlooked that there was a specific mention of transport vehicle in section 3 which would indicate that a license for a light motor vehicle cannot be used for driving a transport vehicle. Mr. Dave further argued that the eligibility for obtaining a license for transport vehicles is more stringent than for light motor vehicles. Since transport vehicles are primarily utilized for carrying passengers and goods, the additional requirements are essential for ensuring road safety. Adverting to Section 4 of the MV Act, which sets out the age limit, the Council highlighted that the minimum age for securing a driving license for motor vehicles is 18 years, but for driving transport vehicles, Section 4.2 provides that the minimum age would be 20. Moreover, to qualify even for a learner's license to drive a transport vehicle, Section 7.1 stipulates that a candidate must have held a driving license for a light motor vehicle for at least 1 year. Section 8.3 mandates that an individual applying for a learner's license for a transport vehicle must submit a medical certificate from a registered medical practitioner attesting to the appellant's physical fitness to operate a transport vehicle. However, such a requirement is absent in the case of a light motor vehicle for which only a self-declaration is sufficient. Additionally, the second proviso to Section 15 of MV Act stipulates that a medical certificate is also necessary for the renewal of a driving license for transport vehicles. Section 9.4 requires that the applicant for a transport vehicle license must possess a driving certificate from a driving school or establishment. It was further submitted that the 1994 amendment to Section 10 merged four classes of medium goods vehicle, medium passenger vehicle, heavy goods vehicle, and heavy passenger vehicle into a single class of transport vehicle under Section 10(2)(e) of MV Act. Section 10(2)(d), on the other hand, provides for a separate class of light motor vehicle. Therefore, the retention of the separate classes of transport vehicle and light motor vehicle under Section 10(2) by the 1994 amendment implies that the two classes are not co-equals and the license holder of a light motor vehicle is not eligible to drive a transport vehicle. A separate license would be mandatory is the argument of the Council. Mr. Jayant Bhushan, learned senior counsel, argued that Mukund Devgan 2017 erred in two significant respects. The judgment overlooked Section 3, which mandates a separate endorsement for driving a transport vehicle. Reliance was placed on the decision in Nathi Devi versus Radha Devi Gupta, where it was held that effort should be made to give effect to each and every word used by the legislature. Therefore, it was projected that the court should not disregard any part of Section 3 in its interpretation. The other reason why Mukund Devgan 2017 was incorrect, according to Mr. Bhushan, was because it focused on the general law rather than the special provisions within the MV Act. It was therefore argued that it is a well known principle that the general will not override the special general. Stop.